Now, Washington Mornings on the Mall. 105.9 FM. At AM 630. WMAL.
7:07 on WMAL. Happy Monday morning to you. Brian Neiman, Brian Wilson with you.
Hey.
It's a big day in D.C. yesterday with the Redskins and Nationals playing at the same time. We'll get into that a little bit later. Ambassador John Bolton's going to be on the program about a half hour from now. We'll talk to him about what's been going on in Benghazi. Also, a big speech today for Governor Mitt Romney, and that speech will be delivered at VMI. Trevor Maddich will be here in the 8 o'clock hour, so a lot to do here with Brian and Brian. Right now, though, Joe diGenova, our legal expert, joins us. Good morning, Joe. How are you?
Hey, Joe.
Good morning, Brian and Brian.
All right, so let me get your take on this WARN Act. This is fascinating because you have in law, which says if there are going to be mass layoffs or plant closings, that a company must give 60 days notice to employees that is the possibility of that their job may be lost. And, of course, we know with the Pentagon and sequestration, these automatic cuts that are going to be happening to defense that take place on January 2nd, many of the big giants and even the small companies in the Defense Department may be forced to lay off a whole lot of people. The administration has come forward and said, well, listen, don't send those notices out because they would show up in somebody's mailbox a couple of days before the election. Don't do that. And if it ever becomes a legal problem for you where you have to go to court, we will cover your legal expenses. So basically, the way we've been talking about it is, paraphrasing, the administration is telling a company to break the law, and if they're found in violation, that they will pay up their legal dues. Mm-hmm. Is this legal in any way?
First of all, it's not legal. The WARN Act makes it very, very clear. There is no permission for a waiver in the WARN Act, which is exactly what the administration is doing. Now, there are also other federal laws that make administrators who do illegal acts personally liable for all the funds that it costs to enforce it and if any money is lost. So that means whoever sent out that waiver and anyone else involved in the project is personally liable for any losses caused to the United States government or to the people who were not warned. So, in other words, what the administration has done is, A, they have violated the WARN Act. Mm-hmm. B, they have violated the other law, which controls the OMB, which says you cannot do something illegal. And if you do, you are personally liable for it. So the person from the Labor Department or DOD or the Office of Management and Budget who sent that letter is personally liable. An injunction can be sought against them. And, in fact, I am amazed that even some of the smaller defense contractors, see, they're all afraid they're going to lose contracts.
Right.
So they don't want to sue. So some other organization has to be able to sue to enforce the WARN Act. That could probably be a think tank or something like that. But this is clearly an illegal act.
But is it illegal right now?
Yes,
I mean,
absolutely. The sending of the letter telling them not to issue the WARN notices was an illegal act.
Okay, so you don't have to wait for there to be mass layoffs and these individuals not getting these 60 days notice.
The case is ripe for litigation right now. The problem is they're going to have trouble finding somebody to sue because the obvious people to sue would be the defense contractors who are going to be sued by their workers if they are laid off and the warnings did not come.
All right, but here's what my question to you, Joe, and I agree with, I'm not a lawyer, but what you're saying seems to make sense to me. But if I'm Lockheed Martin, why would I expose myself to having to make all those payments? Clearly, they have a team of lawyers who've looked at whatever it is that's been handed to them by the Obama administration, and they have found a level of comfort with it. How could they have come to that conclusion?
Well, because the government's told them we're going to cover your legal fees and any damages that you have to pay. The problem is it's not the defense contractor's problem.
Yeah.
They're doing what the government is telling them to do. What the government is telling them to do is illegal.
Right.
Now, they can make their own independent judgment about that, and they can go and sue and say, we're going to issue these notices, but they're not going to do that. That's politics. The legal issue now rests with the government. The government has told someone that it has a duty to act illegally. The government cannot do that absent permission for Congress that there is such a thing as a waiver. in the WARN Act. There is no waiver in the WARN Act. It must be forced. They must be issued. Congress made it very clear that there are no exceptions. The administration is acting illegally. The question is, who's going to hold them accountable?
All right, but do you remember when laws used to actually be laws?
but to Brian's point, though, let me ask you this. Let's just say that Booz Allen doesn't put out notices, and they do have to lay off people, and they go and it goes to court, and they say to the judge, hey, look, I got a waiver here from the government. It's signed. Here's the letter. I mean, they said I didn't have to pay any kind of legal fees.
Here's what could happen to any defense contractor that does that. The court could say, ladies and gentlemen, you're all very smart people. You're not poor people. You're not people on subsistence. You have hundreds of lawyers. You spend millions of dollars on legal fees. You knew this was illegal. You're going to pay it, and I'm going to block indemnification by the government because the indemnification is illegal, and you are liable as a company. What comes next? Shareholders' class action lawsuits against the company. There's plenty of incentive for these people to disregard the waiver notice from OMB. This is absolutely outrageous. If this were Richard Nixon or George W. Bush, the press would be going crazy.
If you were advising these defense contractors, you would say put the notices out?
Issue the notices because the indemnification offer from the government is absolutely useless to you legally. You will be held accountable, and worse than that, class action lawsuits for tens of millions of dollars by shareholders. Shareholders say, what are you doing? Lay these people off. You don't have the right to continue to pay them. Shareholders' lawsuits coming down the pike.
All right, I want to talk to you about the other thing that's on my list of questions to ask you. It has to do with the first sale doctrine. There is a case pending before the Supreme Court that calls into question whether the first sale doctrine, which has been a part of copyright law, I think, forever, might not be legal and might be overturned if an appellate court ruling is upheld. Tell me what you know about this particular case.
Well, this is a fascinating case involving a young gentleman from who lives in the United States who has family in Thailand. His name is Supap Tirtsang. And what he did was he had his family members overseas send him works that were manufactured in the United States but then had been sold overseas. Actually, these particular books of his, these textbooks were printed by an American company's affiliate in Asia. He imported them into the United States, then sold them online and made a handsome profit. The company that printed the books, both in the United States and overseas, sued him and won an injunction against him and damages for around $600,000 that he made off of this, saying that he had violated the Copyright Act. And the Second Circuit Court in New York agreed with the company and upheld it. It's now on its way to the Supreme Court, where the Supreme Court is going to decide whether or not you can sell things which have been only intended for the foreign market but come into the United States without paying a copyright fee again. Remember, these have already been paid for once. They've been shipped overseas. They come back in. Second Circuit says you got to pay copyright fees.
But real quick, I mean, a lot of people are suggesting this could make your garage sale illegal.
Probably not going to affect garage sales because most of these companies don't have the legal resources to follow every garage sale in the United States, but that's not where the money is. The money is in companies like Mr. Kirksang's that buy large quantities of items overseas and then bring them in. By the way, the Supreme Court dealt with this very issue in 2010, and they split 4-4 because Elena Kagan had to recuse herself because she had filed a brief in that case as Solicitor General. This time she'll be able to vote, and the going guess is that they're going to overrule the Second Circuit, and they're going to say that things like this can be reimported into the United States and sold without having to pay a copyright fee. By the way, the biggest people who are concerned about this are people that make and sell games. This is a big deal for them. There's hundreds of millions of dollars in resales of games, electronic games from overseas. That's what this case is about. It's not about books. It's about games.
All right, listen, Joe, thank you very much. Great stuff.
Pleasure, Joe.
Guys, take care.